Welcome to the deep dive. Today, we're jumping into the world of contract law.
It sounds daunting, I know.
It really can.
Hmm.
But we've basically boiled down the core ideas, our mission today, to help you figure out what actually makes a promise legally binding.
And just as importantly, what can make an agreement fall apart, even if it looked solid?
Exactly. We know you want the key insights without getting lost in legal textbooks. So this deep dive is all about giving you a clear, structured handle on the essentials.
Yeah, we're aiming for practical understanding here. Contract law covers a lot of ground, but we're focusing on the stuff you're most likely to run into, the really crucial bits.
All right, let's get started then. What's the absolute bedrock? What makes a promise something the law will enforce?
Well, it really starts with this concept called consideration.
Consideration.
Think of it as the something for something requirement. The legal jargon is legal detriment.
Okay, so legal detriment. It doesn't necessarily mean something bad happens to you, right? It's not like actual damage.
That's a great point. Now, it's not about loss in that sense. It's more about agreeing to do something you didn't have to do before.
Ah,
Uh,
okay. So it could be promising to take on a new task,
yep. Or actually performing an action you weren't legally required to perform.
or even not doing something you have a legal right to do, like agreeing not to sue someone.
Exactly. Giving up a legal right counts. So the key is that both sides are giving something up or committing to something new. It's this mutually bargained for exchange.
Makes sense. So what doesn't count then? What looks like consideration but isn't?
Good question. Well, first off, past action, something you already did before the promise was made, that's generally not valid consideration for a new promise.
Right, the timing matters.
Hugely. Also, if you already have a legal duty to do something, say, a police officer's duty to investigate a crime, promising to do that same thing, isn't new consideration.
Okay, pre-existing duty. What about sham consideration? I've heard that term. Or things that are just way too small.
Right. Sham or nominal consideration, like
Yeah.
promising to sell your car for $1. If it's clear the dollar wasn't really bargained for, if it's just a pretense, courts won't say there's no real consideration.
And illusory promises, like, I'll pay you if I feel like it.
Precisely. If the promise doesn't actually commit the promiser to anything definite, it's illusory and doesn't count. There's no real legal detriment there.
You mentioned promising not to sue earlier. That can be consideration, but there's a catch, isn't there?
Yes, there is. For a promise not to sue to be valid consideration, the person giving up the right to sue must have an honest and good faith belief that their claim is actually valid.
So you don't necessarily have to have a winning case,
No, not at all.
but you have to genuinely believe you have a case, even if objectively it's weak or might fail.
That's the key. Good faith belief. If you know the claim is bogus and you're just using it as leverage, then promising not to pursue it isn't valid consideration.
Okay. And just quickly, the difference between bilateral and unilateral contracts. How does consideration work there?
Sure. Bilateral is the most common. It's a promise exchanged for another promise. I promise to paint your house if you promise to pay me $5,000. The consideration is the mutual promises.
Gotcha.
Unilateral is a promise exchanged for an action or performance. I promise to pay $100 to whoever finds my lost dog. The consideration from the finder is the act of finding the dog, not a promise to look.
And this ties into the objective test, right? It's about how things look from the outside, not secret intentions.
Always. Contract law generally looks at outward manifestations, what was said, what was done, not what someone was thinking privately. That's crucial for determining if there was a real bargain.
Which brings us back to the invalid claims idea. If I promise something based on someone dropping a claim I knew was invalid,
Then your promise probably isn't enforceable for lack of consideration.
but if I genuinely thought their claim might be valid, even if it wasn't airtight.
Then your promise could be enforceable because they gave up something they honestly believed they had a right to pursue.
Okay. Now, do courts actually weigh whether the consideration was, like, fair? Do they step in if someone made a bad deal?
Generally, no. That's a really important point. Courts usually don't inquire into the adequacy of consideration. As long as there is some valid bargain for detriment, they typically won't save someone from a bad bargain.
So the takeaway is you need that legal detriment, that bargain for exchange, but the value isn't usually the court's business unless maybe it's purely nominal or sham.
Pretty much. Freedom of contract means you're generally free to make bad deals as well as good ones.
Okay, but what about situations where a promise is enforced, even if there isn't that formal bargain for consideration? Are there exceptions?
Absolutely. This is where things get interesting. The main one is called promissory estoppel.
Promissory estoppel. Sounds important.
It is. Think of it as a fairness doctrine. It can make a promise enforceable even without consideration if someone reasonably relied on that promise and would be harmed if it wasn't enforced. It's about preventing injustice.
Okay, so reliance is the key word there. Acting on the promise.
Exactly. There are generally 4 elements courts look for.
Let's hear them.
1, there needs to be a clear and definite promise. 2, the promiser should have reasonably expected the promisee to rely on it.
Makes sense.
3, the promisee did actually rely on the promise, often by taking some action or refraining from action. And 4, injustice can only be avoided by enforcing the promise.
So that reliance part, the something must be done because of that promise, that's crucial. If I just heard the promise but didn't change my behavior.
Then promissory estoppel probably wouldn't apply. There has to be that detrimental reliance. You acted or didn't act because of the promise, and now you're worse off.
What about charities? I feel like pledges to charities are often enforced.
Yes, there's a specific rule often applied there, sometimes under the restatement, Second of Contracts, Section 90. It recognizes that charities often rely on pledges for their operations. So, in many jurisdictions, a charitable subscription or pledge can be enforceable even without proving specific detrimental reliance if enforcement is needed to avoid injustice.
Interesting. What about promises within families, like, I'll give you the house if you take care of me?
Generally, promises between close family members are presumed not to be legally binding contracts, often because there's no intent to create legal relations or clear consideration.
But there are exceptions.
There can be, especially if it involves a promise against an estate after someone dies, or if the promise clearly induced one family member to take significant action or forbearance that wouldn't have otherwise, like moving across the country to care for a parent based on that promise of inheriting the house. That might tip into reliance or even a bargain.
Okay. Then there are these quasi-contract things, implied in law.
Right. Quasi-contract isn't really a contract at all. It's a legal fiction, a remedy courts use to prevent unjust enrichment.
Unjust enrichment, meaning someone got a benefit they shouldn't fairly keep without paying.
Exactly. Think of the classic example. A doctor provides emergency services to an unconscious person. There's no agreement, obviously. But the law implies an obligation for the person to pay the reasonable value of those necessary services to prevent the doctor from being unpaid and the patient unjustly enriched.
So benefit conferred, expectation of payment, and unfairness if not paid.
Those are the key elements, yes. Measurable benefit, reasonable expectation of compensation, and unjust enrichment if retained without payment.
How's that different from an implied in fact contract?
Good question. An implied in fact contract is a real contract. It's just that the agreement is shown by the party's conduct rather than explicit words.
Like going to the barber. You sit down, they cut your hair.
And nobody explicitly says, I promise to pay or I promise to cut, but the circumstances clearly imply an agreement to provide the service in exchange for payment. Both parties understand the deal through their actions.
Got it. One more in this category, the material benefit rule.
Yes. This one's a bit less common, but still important. It can sometimes make a promise enforceable, even if it's based on a past benefit received, which normally wouldn't be consideration.
Wait, I thought past consideration was no good.
Usually it isn't, but the material benefit rule is an exception. If someone receives a significant material benefit from another, who wasn't just being a gift giver, and then promises to pay for that benefit, that promise can be enforceable, but only to the extent necessary to prevent injustice. Think of someone saving another person's life, and the saved person later promises a reward.
Okay, so it's like recognizing a moral obligation arising from a past material benefit.
Kinda, yeah. But it's a narrow exception.
All right, that covers the exceptions and quasi-contracts. Let's circle back to building a real contract. It all starts with an offer, right?
Absolutely. The offer is step one. Legally, it's a manifestation of willingness to enter into a bargain, made in a way that justifies the other person, the offeree, in understanding that their assent is invited and will conclude the deal.
So it basically gives the other person the power of acceptance. They can just say yes.
Exactly. That's the key phrase. It creates the power of acceptance.
Which makes it different from just like testing the waters, an invitation to negotiate.
Precisely. An invitation to negotiate, like saying, would you consider selling your car for $10,000? doesn't show that final willingness to be bound. It lacks that manifest to assent upon a simple yes.
Generally, an offer has to be aimed at a specific person, right?
That's the usual rule,
Yeah.
yes. You offer to sell your car to a specific person.
But what about things like reward posters? Lost dog, $100 reward. Or contests.
Those are exceptions. The offer is made to anyone who performs the required act. Finding the dog, winning the contest. The performance is the acceptance.
And advertisements. Usually not offers.
Right, usually just invitations to deal. Stores aren't typically bound to sell you everything in their ad at the advertised price if they run out.
But again, exceptions.
Yes, if an ad is really specific, clear, definite, and leaves nothing open for negotiation, especially if it includes language like first come, first served, or specifies quantity, time, place, price terms, then it might be treated as an offer.
Okay. What about price quotes or price lists?
Generally, also not offers, just providing information.
Can they become offers?
They can, yeah.
Yeah.
If a price quote is sent in response to a specific inquiry about a known quantity, includes detailed terms like delivery, product choice, and maybe crucially has a short deadline for acceptance, it might cross the line into being an offer.
It all comes down to that objective willingness to enter the agreement, doesn't it?
It really does. Again, it's not about what the offerer secretly intended. It's about how their words and actions would appear to a reasonable person in the offeree's position.
Does the offerer's state of mind matter at all? Like if they were obviously joking or maybe too drunk?
Well, objective intent is key, but extreme circumstances can affect it. If it was objectively clear to everyone that it was a joke, no reasonable person would think it's a real offer. And yes, severe intoxication could potentially negate the required intent if the other party knew or should have known they were too incapacitated to make a serious offer.
Okay. For an offer to be valid, it needs to contain the essential terms, right? What are those generally?
Under common law, which applies to services, real estate, etc., you typically need the parties, the subject matter, the quantity, and the price. Those are the big four.
But it's different for sales of goods under the UCC.
It is. The Uniform Commercial Code is a bit more flexible for goods. You still need the parties, subject matter, and quantity. But crucially, a contract for goods can sometimes be formed even if the price isn't settled initially, as long as the parties intend to be bound. The UCC has gap filler provisions for price in those cases, like a reasonable price at the time of delivery.
That's a big difference. Quick aside, if you want to modify an existing common law contract,
Under traditional common law, you generally need new consideration on both sides for a modification to be enforceable. You can't just agree to change a term without some new bargain. The UCC is different here too, but we'll get to that.
got it. What about those contracts where the quantity isn't fixed up front, like requirement contracts or output contracts?
Right. A requirement contract is where a seller agrees to supply all that a buyer requires. An output contract is where a buyer agrees to purchase all that a seller produces.
The quantity seems fuzzy there. How does that work?
The quantity isn't fixed, true, but it's not unlimited either. It's governed by good faith. A buyer in a requirement contract can't suddenly demand a hugely disproportionate amount compared to past needs or reasonable estimates. And importantly, they generally can't reduce their requirements to zero just to get out of the deal if they still have requirements that would likely be bad faith.
So good faith acts as the limit. If an agreement is just too vague, missing key terms, it's usually unenforceable.
Generally, yes. If it lacks important or definite terms, courts often find there was no real meeting of the minds. But again, the UCC is more forgiving with goods contracts, allowing gap fillers if the parties clearly intended to make a contract.
This seems relevant to, say, settlement negotiations. Parties might reach a preliminary agreement but plan a formal document later. Is that initial agreement binding?
That's a common issue. Courts often use a four-factor rule for settlement agreements, and similar principles apply elsewhere to see if a preliminary agreement was meant to be binding immediately.
What are those factors?
They look at 1. Did the parties explicitly reserve the right not to be bound until a formal writing was signed? 2. Has there been any partial performance of the agreement? 3. Were all the essential terms actually agreed upon? And 4. Is this type of agreement usually put into a formal written contract?
Based on those, you might have different types of preliminary agreements.
Exactly. You might have a Type I preliminary agreement, where the parties have agreed on all the essential terms and intend to be bound now, even though they plan a more formal document later. That's fully binding.
Okay, and type 2?
A Type 2 is different. It's more like an agreement to negotiate in good faith. The parties have committed to working towards a final contract on the agreed-upon framework, but they haven't agreed on all the terms yet, and there's no guarantee they'll reach a final deal. It binds them to negotiate fairly, but not necessarily to the ultimate contract itself.
And courts look at specific factors to decide if it's type I or type 2.
Yes, factors like the language used, did they say they intend to be bound? The context of negotiations, how many terms are still open, whether there's been partial performance, and the complexity, does it seem like a deal that needs a final formal document?
Okay, so an offer is out there, but it doesn't last forever, right? How can an offer be terminated?
Right, an offer can die before it's accepted. Once terminated, it's gone. Acceptance is no longer possible unless a new offer is made.
How can the person who made the offer, kill it?
Several ways. The most direct is revocation. Just telling the offeree, I revoke my offer. That's effective when the offeree receives it.
What if they don't say it directly?
Revocation can also happen indirectly. If the offeree reliably learns that the offerer has taken action completely inconsistent with the offer remaining open, like they see the offerer selling the specific car they were offered to someone else, that can count as revocation.
What about death? Or if the offer becomes incapacitated?
That also terminates the offer automatically by operation of law. And interestingly, this is generally effective upon the death or incapacity itself, not necessarily when the offeree learns about it, although reliable confirmation would certainly end the power of acceptance.
And just time.
Yep. An offer lasts after a reasonable amount of time passes. What's reasonable depends entirely on the context. An offer to sell volatile stocks might lapse in minutes, while an offer for real estate might last weeks. If an offer is made during a conversation, the general rule is it lapses when the conversation ends, unless specified otherwise.
Okay, so the offer can terminate it. Can the offeree?
Absolutely. The offeree can terminate the offer by expressly rejecting it, saying no thank you.
Or by making a counteroffer.
Exactly. A counteroffer, I'll buy it, but only for $9,000 instead of $10,000, generally acts as a rejection of the original offer and proposes a new offer. The original offer is dead.
Any other ways, like operation of law again?
Yes. If the subject matter of the offer is destroyed before acceptance, the car burns up, or if the proposed contract becomes illegal after the offer is made but before acceptance, the offer terminates automatically.
But sometimes offers can't be revoked, right? Irrevocable offers.
Correct. One common way is through an option contract.
How does that work?
An option contract is basically a mini contract about the main offer. The offeree gives the offerer some consideration. It doesn't have to be much. Even a promise to pay later can suffice in exchange for the offerer's promise to keep the main offer open for a specified period. That promise to keep the offer open is now binding.
So consideration is key for a common law option. What about under the UCC for goods?
The UCC has a special rule called a firm offer. Under Section 2205, an offer by a merchant to buy or sell goods made in a signed writing, which explicitly promises to hold the offer open, is irrevocable for the time stated, or a reasonable time, but capped at 90 days, even without consideration.
Merchant being someone who deals in those goods or holds themselves out as having special knowledge.
Yes, that's the UCC definition. So, signed writing by a merchant promising to keep it open, that's a firm offer. No extra consideration needed.
What about those unilateral contracts promise for an act, like the Find My Dog example? Can you revoke when someone starts looking?
Ah, good question. The traditional rule was yes, you could revoke any time before full performance. But the modern view, and the one of the restatement, is that once the offeree begins performance, an option contract is created implicitly. The offerer can't revoke, and the offeree has a reasonable time to complete the performance.
So starting the act makes it irrevocable temporarily.
Pretty much, yes. Note that mere preparations to perform generally don't count, though. Buying supplies might not be enough. You usually have to actually start the requested act.
Oh,
Unless the preparations themselves involve significant detrimental reliance.
Ah, reliance again. So detrimental reliance can make an offer irrevocable too.
Yes. If an offerer should reasonably expect their offer to induce substantial reliance by the offeree before acceptance, and it does, the offer can become irrevocable as an option contract to the extent needed to avoid injustice. Think of a general contractor relying on a subcontractor's bid to make their own main bid.
Okay, that makes sense. Let's shift gears slightly to the things inside a contract that might not be explicitly spelled out, implied terms and clauses.
Right, not everything's written down. The law often implies certain promises or terms into contracts based on context, custom, or fairness. These implied promises can be just as enforceable as express ones.
Like best efforts clauses. Sometimes those are written, sometimes implied.
Exactly. A best efforts clause, whether express or implied in certain situations, like exclusive dealing arrangements, requires a party to use a high level of diligence and due care in performing their obligations. It's more than just good faith. But it usually doesn't require them to bankrupt themselves. They can typically still consider their own financial well-being to some extent.
What about employment contracts, the at-will doctrine?
Right. The default rule in most U.S. states is employment at will. This means either the employer or the employee can terminate the relationship at any time for any reason, good or bad, or no reason at all, as long as the reason isn't illegal, like discrimination.
But there are exceptions to at-will.
Yes, quite a few have developed. Termination might be wrongful if it violates a clear public policy, like firing someone for refusing to commit perjury. Sometimes, statements in an employee handbook or personnel manual can modify the at-will status, creating implied contractual promises. And many states recognize an implied covenant of good faith and fair dealing in employment, which prevents firing someone in bad faith to deprive them of earned benefits, though it usually doesn't require good cause for termination itself.
Then there are those restrictive covenants, like non-competes.
Yes, non-competition agreements. These restrict an employee's ability to work for a competitor or start a competing business after leaving employment.
Are they always enforceable?
No, far from it. Courts scrutinize them closely. To be enforceable, a non-compete must protect a legitimate business interest of the employer, like trade secrets or customer relationships. It must be reasonable in scope, the type of activity restricted, duration, how long it lasts, and geographic area, and it can't impose undue hardship on the employee or harm the public interest. Reasonableness is very fact-specific.
Some places are really cracking down on them, especially for certain professions, right?
Absolutely. Some states heavily restrict or ban them entirely, especially for lower wage workers or professions like physicians, often citing public policy concerns.
What if a non-compete is mostly okay, but one part is too broad? Like the time limit is too long.
That's where the blue pencil doctrine might come in, depending on the state. Some courts will blue pencil the contract, basically, cross out or delete the unreasonable part, like changing 5 years to 1 year, if 5 is too long, to make the rest enforceable. Other courts refuse to rewrite and will just strike the whole clause if any part is bad. They generally won't add terms, though.
Okay, we have an offer. It hasn't been terminated. Now someone needs to say yes. Let's talk acceptance.
Acceptance. This is where the contract is actually formed. The offeree needs to show they agree to the terms of the offer.
What does the offeree need?
Well, first, they need the power of acceptance. The offer must have been directed to them, or they must be part of the group it was directed to, like even a reward. And they need to be aware of the offer, especially for rewards. You can't accidentally accept an offer you didn't know existed.
And again, it's about outward appearance.
Yes, they have to manifest that objective willingness to enter into the agreement. What would a reasonable offerer think based on their words or actions? Secret intentions don't matter.
And crucially, they have to accept according to the rules the offerer set up, right? The offerer is the master of the offer.
That's the phrase. If the offer specifies how acceptance must occur, for example, by certified mail only, then the offeree generally has to follow those instructions for the acceptance to be valid.
How does acceptance differ for bilateral versus unilateral offers?
For bilateral offers, promise for a promise, acceptance is usually another promise that clearly indicates agreement to the terms. It could be verbal, written, or sometimes even implied by starting performance in a way that signals a promise to finish.
And unilateral, promise for an act.
Acceptance is the completion of the requested performance. Remember, starting performance usually makes the offer irrevocable for a reasonable time. But acceptance only happens when the act is fully done.
What if the offerer wouldn't necessarily know the act was completed? Like, if I promise $100 to anyone who paints my fence while I'm out of town.
Good point. If the performance isn't obvious, the offeree might need to give notice of completion within a reasonable time for the acceptance to be effective, unless the offerer waived notice or would likely learn of it anyway.
Okay. Can silence ever count as acceptance? Usually not, right?
Usually not. You can't typically force someone into a contract by saying, if I don't hear from you by Friday, you've accepted.
But there are exceptions.
Yes, in specific circumstances. If the offeree silently takes the benefit of offered services with a reasonable opportunity to reject them, knowing they were offered with the expectation of payment, or if the offer indicated silence would be acceptable, or if prior dealings between the parties have established silence as a reasonable mode of acceptance.
What about those book clubs or subscription services? Send this back if you don't want it.
That can be tricky. Sometimes those are based on a prior agreement. You signed up agreeing to the negative option. If there's no prior agreement, just sending unsolicited goods and saying silence is acceptance is often legally ineffective. The recipient might be able to treat it as a gift in some jurisdictions. Taking dominion over offered goods might sometimes count as acceptance, though.
Okay, let's talk timing, especially with mail or email. The mailbox rule.
Ah, yes. The mailbox rule is the default rule for acceptance, communicated through means like mail, email, or fax, when those were common. It states that acceptance is effective upon dispatch when it's sent, put out of the sender's control, not when it's received by the offerer.
So if I mail my acceptance letter on Monday and you revoke your offer on Tuesday before my letter arrives, we still have a contract.
Under the default mailbox rule, yes. Your acceptance was effective Monday when you mailed it.
Wow. Are there exceptions to this? When does it not apply?
Yes, several important ones. It doesn't apply if the acceptance is sent to the wrong address or without proper postage, causing significant delay. It doesn't apply if the offer specifically stipulated that acceptance is only valid upon receipt.
Okay. What else?
It generally doesn't apply to option contracts. Acceptance under an option usually needs to be received by the deadline. Also, if the offeree sends a rejection or counteroffer first and then sends an acceptance, the mailbox rule is off. Whichever communication arrives first controls.
One more scenario.
If the offeree sends an acceptance, then sends a rejection revocation, the acceptance is effective on dispatch, unless the rejection arrives first. And D, the offer detrimentally relies on that rejection before the acceptance arrives. It gets complicated, but dispatch is the default.
Okay, things get messy when the acceptance isn't a perfect mirror image of the offer, counteroffers, and the battle of the forms.
Right. As we said, a counteroffer usually kills the original offer and proposes a new one. The original offer now has the power of acceptance for the counteroffer.
And under common law, you have that strict mirror image rule, correct?
Correct. The acceptance has to match the offer terms exactly. Any variation, even minor, makes it a counteroffer, not an acceptance.
What about saying something like, I accept and I hope I can pick it up on Monday? Is that a counteroffer?
That's likely a valid acceptance with an independent condition or request. It doesn't make the acceptance dependent on picking it up Monday, but if you say, I accept only if you replace the tires first, that is making acceptance conditional on a new term, so it becomes a counteroffer.
This mirror image rule could lead to the last shot doctrine, right? Explain that.
Yeah, it's a consequence of the mirror image rule. If parties exchange forms with different terms, like purchase orders and invoices, and then they start performing, shipping goods, paying, the law often treats the last form sent before performance began as the final counteroffer. And the performance itself, like accepting the shipped goods, is treated as acceptance of the terms on that last form. The last shot wins.
That seems potentially unfair. Does the UCC handle this differently for goods?
Drastically differently. This is where UCC Section 2207, the infamous Battle of the Forms provision, comes in. It's designed to handle situations where merchants exchange pre-printed forms with conflicting terms, but act like they have a contract.
So under 2207, an acceptance doesn't have to be a mirror image.
Correct. Section 2207(1) says a definite and seasonable expression of acceptance or a written confirmation sent within a reasonable time operates as an acceptance even if it states terms additional to or different from those offered, unless the acceptance is expressly made conditional on the offerer's assent to the new or different terms. That proviso language turns it back into a counteroffer. Something like, this acceptance is expressly conditional on your agreement to our standard arbitration clause.
Okay, so assuming it's not expressly conditional, we have an acceptance, but it has new terms. What happens to those additional terms, especially if both parties are merchants?
Good question. That's UCC 22072. Between merchants, additional, not different, we'll get to that, terms automatically become part of the contract, unless one of three things happens.
What are the exceptions?
1. The original offer expressly limited acceptance to its own terms. 2. The new terms materially alter the contract, like significant price changes, warranty disclaimers if warranties were discussed, arbitration clauses are often litigated. Or 3. The offer objects to the additional terms within a reasonable time after receiving them.
So if none of those apply, the merchant's additional terms sneak into the deal.
Pretty much, yeah.
What if the terms are not additional but different? they directly conflict with terms in the offer. QG offer says net 30 days, acceptance says net 60 days.
The treatment of different terms under 22072 is controversial, but the majority approach, followed by most courts, is the knockout rule.
Knockout rule.
Yeah, the conflicting terms in the offer and acceptance simply knock each other out. Neither term becomes part of the contract.
Then what fills the gap?
The UCC's own gap filler provisions are used instead. So for payment terms, the UCC might imply payment is due on delivery, for example.
What if the forms are so different they don't even form a contract under 22071, but the parties start acting like they have one anyway? Shipping goods, paying.
That's covered by UCC 22073. If the writings don't establish a contract, but the parties' conduct shows they believe one exists, then a contract is formed. The terms are the ones on which the writings agree, plus any UCC gap fillers for missing terms. The knockout rule effectively applies here too.
Wow, okay. 2207 is complex, but definitely tries to reflect business reality better than the last shot doctrine.
It certainly tries, though it leads to its own set of complexities.
All right, we formed a contract, maybe navigated the battle of forms, but are there ways someone can get out of it? Let's talk defenses to enforceability.
Definitely. Just because offer, acceptance, and consideration seem present doesn't mean the contract is ironclad. Incapacity is a major defense category.
Starting with minors, or infants in legal terms.
Right. Contracts entered into by minors are generally voidable at the minor's option. They can choose to disaffirm, rescind the contract anytime while they're still a minor, or for a reasonable punctual after reaching the age of majority.
What happens if they disaffirm?
They usually have to return whatever consideration they still have left, like the car, even if it's damaged. If they don't disaffirm within a reasonable time after turning 18, they might be considered to have ratified the contract, making it fully binding.
Does emancipation change this?
Generally, no. Even an emancipated minor usually retains the power to disaffirm contracts.
Okay. What about mental illness or defect?
Similar principle. If a person, due to mental illness or defect, was unable to understand the nature and consequences of the transaction, or they were unable to act in a reasonable manner regarding the transaction, and the other party had reason to know this, the contract is voidable by the person with the incapacity.
What if they've been formally declared mentally incompetent by a court?
Then any contracts they enter into are typically void from the start, not just voidable.
So medical proof is needed.
Yes. Usually medical evidence showing their condition at the time they entered the contract is required to establish the defense.
And intoxication. Can being drunk get you out of a contract?
It can, but it's a high bar. The intoxication must be severe enough that the person couldn't understand the nature and consequences of the transaction or couldn't act reasonably, and the other party has to have known or had reason to know about the level of intoxication. Like mental incapacity, it makes the contract voidable. The intoxicated person has to act promptly to disaffirm once they sober up.
But even if someone lacks capacity, they might still have to pay for essentials.
Yes, the necessaries doctrine.
Yeah.
Parties lacking capacity, minors, sometimes mentally ill or intoxicated individuals, are generally liable under a quasi-contract theory for the reasonable value, not necessarily the contract price, of necessaries furnished to them, things like food, shelter, clothing, medical care.
Okay, moving beyond capacity. What about shady behavior during negotiations, like hiding information, concealment?
Intentional concealment, actively hiding a material fact that the other party should know, can make a contract voidable. Even conduct that prevents someone from learning a fact can be treated like an assertion that the fact doesn't exist.
Is there always a duty to disclose information?
Not always. Arm's-length transactions often don't require full disclosure. But a duty to disclose can arise in certain situations, making non-disclosure equivalent to a misrepresentation.
Like when?
If you made a statement earlier that you later find out is false before the contract is signed, if you know disclosure is needed to correct a mistake the other party is making about a basic assumption, and non-disclosure amounts to bad faith. If you know the writing doesn't accurately reflect the agreement, or, crucially, in relationships of trust and confidence, like between a trustee and beneficiary.
Materiality matters here too, right? Does the hidden fact have to be important?
Yes, it generally has to be material, something likely to affect a reasonable person's decision to enter the contract. Things like the history or reputation of real property, like a house being haunted or the site of a crime, can be deemed material in some cases.
Let's talk mistake. What if both parties are wrong about something fundamental?
That's mutual mistake. If both parties were mistaken about a basic assumption on which the contract was made, like believing a painting is genuine when it's a fake, the mistake has material effect on the agreed exchange. And D, the adversely affected party, didn't bear the risk of that mistake, then the contract is voidable by that party.
Who bears the risk?
Sometimes the contract allocates it.
Mhm.
Sometimes a party bears the risk if they knew they had limited knowledge but treated it as sufficient conscious ignorance. Or the court might allocate it if reasonable.
What if only one party is mistaken? Unilateral mistake.
Much harder to get relief for unilateral mistake. You need all the elements of mutual mistake. Basic assumption, material effect, didn't bear risk. PLUS, either the mistake makes enforcement unconscionable, or the other party knew about the mistake or caused the mistake. Think of a contractor making a huge calculation error in their bid, and the other party knew it was way too low but snapped up the offer.
Okay. What if the mistake isn't about a fact, but about the meaning of a word in the contract? Misunderstanding.
Ah, the peerless ship case scenario.
Mhm.
If a term has multiple meanings, and neither party knows or should know the other has a different meaning, there's no contract unless they happen to intend the same meaning. Same result if both knew or should have known of the ambiguity. But if one party knew or should have known the other had a different meaning and the other party was ignorant, the contract is formed based on the ignorant party's reasonable meaning.
Yeah, outright fraud. There are different types.
Yes, fraud in the factum, or execution, is rare. It's when you trick someone into signing something completely different from what they thought they were signing. Example, telling them it's an autograph request when it's a deed. This makes the contract void.
And the more common type.
Fraud in the inducement. This involves a fraudulent misrepresentation of a material fact.
What are the elements?
The misrepresentation must be made knowingly or recklessly, without regard for the truth. With the intent to induce the other party to agree, it must actually induce their agreement, and their reliance on the misrepresentation must have been justifiable. This makes the contract voidable by the defrauded party.
Does opinion count as fact here? This car is great.
Generally, no. Puffery or statements of opinion aren't usually actionable fraud unless it's an expert opinion given to a layperson, or the opinion implies underlying facts that are false.
What if the misrepresentation wasn't intentional, just careless or innocent?
That's non-fraudulent misrepresentation, negligent or innocent. The elements are similar to fraud in the inducement. Material misrepresentation, induced assent, justifiable reliance, but without the requirement of intent or recklessness. It also makes the contract voidable.
Okay, let's talk pressure tactics. Duress.
Duress occurs when someone is induced to enter a contract by a wrongful act or threat that overcomes their free will. The focus is subjective. Did it overcome this particular victim's will?
What makes a threat wrongful or improper?
Threats of crime or tort, threats of criminal prosecution, threats involving bad faith use of the civil legal process, or threats that breach the duty of good faith and fair dealing. Also, a threat might be improper if the resulting exchange is unfair and the threat involves harming the recipient without significant benefit to the threatener, or exploits prior unfair dealing, or uses power for illegitimate ends.
And a key part is having no other option.
Yes. Often a crucial element is that the victim had no reasonable alternative but to agree. Mere hard bargaining or taking advantage of someone's financial need isn't usually duress unless the pressure involves a wrongful act. Duress makes a contract voidable.
What about undue influence? How is that different?
Undue influence is related, but focuses more on the abuse of a relationship of trust or dominance. It requires showing the victim was unduly susceptible to pressure due to the relationship, their condition, lack of expertise, and the other party applied excessive pressure.
Are there specific signs of excessive pressure?
Courts often look at the Odorizzi factors. Discussion consummation at an unusual time or place, insistent demands for immediate completion, extreme emphasis on consequences of delay, use of multiple persuaders against one party, absence of third-party advisors, statements discouraging consultation with advisors. Undue influence also makes a contract voidable.
What if the contract itself is for something illegal?
If the consideration or the performance required by the contract is illegal, example, the contract to commit a crime, the contract is generally void and unenforceable.
Are there exceptions?
Maybe. If one party was justifiably ignorant of the illegality and the other knew, or if the contract is divisible into legal and illegal parts, courts might enforce the legal parts, or if the parties aren't equally blameworthy, the less culpable party might get restitution.
What if the purpose is illegal, but the performance itself isn't? Like renting a truck knowing the renter plans to use it for smuggling.
If only the purpose is illegal, The contract may be voidable by a party who was unaware of the illegal purpose or who knew but didn't facilitate it, provided the purpose doesn't involve grave social harm.
Okay. One more big defense. Unconscionability.
Right. This is the court's power to refuse to enforce a contract or clause that is just shockingly unfair or oppressive. It usually requires showing both procedural unconscionability, a defect in the bargaining process like hidden terms, fine print, complex language, unequal bargaining power, lack of meaningful choice. Think adhesion contracts sometimes,
And substantive unconscionability.
meaning the terms themselves are grossly unfair or one-sided. Excessively high prices, harsh penalty clauses, severe limitations on remedies. The UCC specifically allows courts to refuse enforcement, strike the clause, or limit its application to avoid an unconscionable result.
Lastly, what about contracts that just seem wrong, immoral?
Yeah. Sometimes contracts that don't fit neatly into other categories might be unenforceable on public policy grounds if they're deemed highly immoral. Perhaps exploiting vulnerable people, treating human life as a commodity, or unduly infringing on fundamental rights like parental rights without justification.
Wow, lots of ways a seemingly valid contract can be challenged. Let's move to a procedural hurdle. The statute of frauds. When does a contract have to be in writing?
The statute of frauds requires certain specific types of contracts to be evidenced by a signed writing to be enforceable. If a contract falls within the statute but isn't in writing, it's typically unenforceable, even if all the other elements offer acceptance consideration are there.
First, how do we know if common law or UCC rules apply if a contract involves both goods and services, like installing a custom appliance?
Courts use the predominant purpose test. They look at the transaction as a whole was the main point to buy the goods or to receive the service. Whichever dominates determines whether the UCC for goods or common law for services governs the entire contract, including the statute of frauds analysis.
Okay. What types of contracts fall under the statute of frauds? Is there an easy way to remember?
There's a common mnemonic, MOUSER.
MOUSER. Okay, break it down.
M is for marriage. This applies to contracts made in consideration of marriage. So not the actual promises to marry each other, but agreements like, if you marry my son, I'll give you $10,000, or prenuptial agreements.
Oh?
O is for the one-year provision. This covers contracts that, by their explicit terms, cannot possibly be fully performed within 1 year from the day after the contract is formed. If there's any theoretical possibility of completing it within a year, however unlikely, it's outside this provision.
So a contract for life could theoretically end within a year.
Exactly. So a lifetime employment contract is usually outside the 1-year provision. But a contract to perform a specific service 2 years from now would be inside. Under common law, full performance of services by either side can sometimes satisfy the statute even if the other side's performance takes longer. U is for UCC contracts for the sale of goods for $500 or more. This is a big one. If you're selling goods worth $500 plus security, you need some writing sufficient to indicate a contract has been made.
What kind of rating? Does it need all the details?
No, the UCC is flexible here. It just needs to show a contract for sale was made, be signed by the party you're trying to enforce it against, and state the quantity. Price, delivery terms, etc. can often be omitted or proven by other evidence. A signature can be initials, type, name, even an e-signature.
Are there ways to satisfy the UCC statute of frauds without a fully signed contract?
Yes, the UCC has exceptions, sometimes remembered by the mnemonic PAWS. P is for performance. The contract is enforceable for goods that have already been paid for and accepted, or received and accepted. A is for admission. If the party you're suing admits in court, in pleadings, testimony, that a contract was made, it's enforceable up to the quantity they admit.
Oh.
W is for written confirmation between merchants. If two merchants make an oral deal, and one sends a signed confirmation within a reasonable time, it satisfies the statute against the receiving merchant if they have reason to know its contents and don't object in writing within 10 days of receiving it. The merchant confirmation rule.
My does.
S is for specially manufactured goods. If goods are being specially made for the buyer, aren't suitable for sale to others in the ordinary course of business, and the sellers made a substantial beginning on their manufacture or commitments for their procurement before repudiation, the oral contract is enforceable.
Okay, back to MOUSER. What's the first S?
S is for suretyship. This is a promise to pay the debt of another person if that person defaults. It's a promise made directly to the creditor. If my son doesn't pay his rent, I will.
Is there an exception?
Yes, the main purpose or leading object rule. If the surety's main purpose in making the promise is to secure some economic benefit for themselves, rather than just helping the debtor, the promise is outside the statute and doesn't need to be in writing.
E.
E is for executor or administrator of an estate. This covers a promise by the executor or administrator to personally pay a debt of the deceased's estate out of their own funds. Promises to pay from estate assets don't count.
And R.
R is typically for real estate contracts. Agreements for the transfer of an interest in land sales, leases for more than 1 year in most states,
Yep.
mortgages, easements must be in writing. Agreements just to build something on land usually aren't included.
So if a contract falls under MOUSER, what does the required signed writing need to contain?
It needs to be signed by the party against whom enforcement is sought, the defendant. It needs to reasonably identify the subject matter of the contract. It needs to indicate that a contract has been made between the parties or offered by the signer, and it needs to state with reasonable certainty the essential terms.
Which terms are essential?
Under common law, that usually means parties, subject matter, and all essential terms like price and quantity. Under the UCC, for goods $500 plus, as we said, it's less strict. Usually just needs to evidence a contract, be signed, and state the quantity.
Okay, so we have a written contract, maybe one required by the statute of frauds. Now, what happens if someone tries to introduce evidence of agreements or negotiations that happened before or at the same time as the writing? That's the parole evidence rule, isn't it?
Exactly. The parole evidence rule limits the extent to which parties to a written contract can introduce evidence of prior or contemporaneous agreements, oral or written, to contradict, vary, or add to the terms of the written contract if the written contract was intended to be the complete and final agreement.
Important point. It only applies to things said or written before or at the same time as the final writing, not later agreements.
Crucial distinction. Agreements made after the written contract are modifications, not parole evidence. The rule doesn't bar evidence of subsequent modifications.
So how does it work? What's integration?
Integration refers to the extent to which the written contract is intended as the final expression of the parties' agreement. A fully integrated contract is intended to be a complete and exclusive statement of all terms. A partially integrated contract is intended to be final regarding the terms it does contain, but not necessarily all terms.
How do you know if it's fully integrated? Is a merger clause conclusive?
A merger clause, saying this writing contains the entire agreement between the parties, is strong evidence of full integration, but not always conclusive, especially if it was boilerplate or fraudulently included. Courts look at the writing itself and the surrounding circumstances.
So if it's fully integrated.
Then evidence of prior or contemporaneous agreements or negotiations, parole evidence, is generally inadmissible to contradict or supplement the writing.
And if it's only partially integrated.
Then parole evidence is inadmissible to contradict the written terms, but it can be omitted to supplement the writing with consistent additional terms, terms that don't clash with the writing.
Does the UCC have a similar rule for goods?
Yes. UCC 2202 follows the same basic concepts of integration. Written terms intended as a final expression may not be contradicted by prior or contemporaneous agreements, but they can be explained or supplemented.
Are there situations where parole evidence is always allowed, even if the contract seems fully integrated? Exceptions to the rule?
Yes, several important exceptions. Parole evidence is generally admissible to
1.
show defects in formation, things like incapacity, fraud, duress, mistake, illegality, lack of consideration. Basically, to show the contract isn't valid in the first place.
Well,
Though fraud related to the merger clause itself might be needed if there is one.
2.
Prove the existence of a condition precedent to the contract becoming effective, like an oral agreement that the written contract wouldn't take effect unless financing was approved.
3.
To resolve ambiguity. If a term in the writing is genuinely ambiguous, evidence can be admitted to clarify its meaning. The modern approach allows judges to consider parole evidence even just to determine if an ambiguity exists, not just to resolve one already found. To show a separate, distinct collateral agreement between the parties. Under common law, this might be allowed if it's something that might naturally be omitted from the main writing. Under the UCC, it's admissible if the term would not certainly have been included in the main writing and doesn't contradict it.
Any others?
Evidence of contemporaneously signed writings might be considered part of the overall agreement. And evidence of subsequent modifications, as we said, is not barred by the rule.
How do courts actually interpret the terms once they decide what evidence they can look at?
There are different approaches. The older Four Corners approach said if the writing appears complete and unambiguous on its face, you only look within the four corners of the document. The modern approach, more common now, allows consideration of all relevant extrinsic evidence to determine the party's intent, even if the writing seems clear on its face.
And the UCC approach?
UCC 2202 is quite liberal. It allows terms to be explained or supplemented by course of dealing, how these parties acted in past contracts, usage of trade, industry customs, and course of performance, how they've acted under this contract so far, unless the writing carefully negates these. Consistent additional terms can also supplement, unless the court finds the writing was intended as a complete and exclusive statement. Using that certainly would have been included tests for collateral agreements.
Are there general rules of thumb for interpretation?
Yes, things like specific terms, control over general terms, handwritten or typed terms, control over pre-printed boilerplate, ambiguities are often construed against the party who drafted the contract, interpretations that make the contract lawful and effective are preferred, and the primary purpose of the contract is given great weight.
What if the parties just had different reasonable interpretations of a term?
If one party knew, or should have known, of the other's different interpretation, and the other party was unaware, the unaware party's meaning often controls. If neither knew or should have known, or both knew, and they meant different things, there might be no contract due to lack of mutual assent on that term, or a court might supply a reasonable term.
Okay, let's move on. Sometimes a contract's obligations don't kick in until something happens, or something can happen to change the deal later. Conditions and modifications.
Right. A condition is an event, not certain to occur, which must occur, unless its non-occurrence is excused, before performance under a contract becomes due.
So it's like a trigger.
Exactly. The default is usually that payment is due only after full performance, but contracts often have explicit conditions.
What are the types? Precedent, subsequent.
A condition precedent is an event that must happen before an obligation arises. I'll buy your house if I can get financing. Getting financing is the condition precedent to my duty to buy. The plaintiff usually has to prove the condition occurred.
And subsequent.
A condition subsequent is an event that, if it occurs after an obligation has already arisen, discharges that obligation. I'll pay you $100 per month unless the company goes bankrupt. Bankruptcy is the condition subsequent that kills the payment duty. The defendant usually has to prove this occurred. Courts tend to prefer interpreting conditions as precedent if possible.
What about concurrent conditions?
That's when performances are due at the same time, like in a typical house closing payment and deed delivery happen simultaneously. Each party's duty is conditional on the other party tendering, offering their performance. Neither can sue for breach until they've tendered.
Can a party give up the benefit of a condition, waive it?
Yes, that's waiver. It's voluntarily giving up a known right or benefit.
How can waiver happen?
It can be by election, choosing to proceed with the contract, despite the non-occurrence of a condition that was for your benefit, like accepting late delivery without objection. Or it can be by estoppel, if you indicate you won't insist on a condition before it's due, and the other party detrimentally relies on that statement, you might be stopped from enforcing the condition later.
Okay. What about changing the contract itself after it's formed? Modifications.
Parties can always agree to modify their contract. As we noted, common law usually requires new consideration for modifications.
But the UCC is different.
Yes, UCC 2209 famously states that an agreement modifying a contract for the sale of goods needs no consideration to be binding as long as it's made in good faith.
What about those no oral modification clauses? This contract can only be amended in writing. Are those effective?
Under the UCC, such clauses are generally effective. If a contract between merchants has one, it's enforceable. If it's on a form supplied by a merchant to a non-merchant, the non-merchant usually has to separately sign that specific clause for it to be effective against them.
Do modifications themselves ever need to be in writing under the statute of frauds?
Yes. If the contract as modified falls within the statute of frauds, for example, the modification pushes the total price of goods over $500, then the modification itself generally must satisfy the statute, usually by being in writing.
What if an attempted modification fails like it's oral but needed to be written? Can it still have an effect?
Yes, under UCC 2209, even an ineffective attempt at modification can sometimes operate as a waiver of the original term.
Can a waiver be retracted?
Generally, yes. A party can retract a waiver regarding future performance by giving reasonable notice, unless the other party has already materially relied on the waiver.
Okay, let's talk warranties promises about the goods being sold, express warranties.
Under UCC 2313, an express warranty is created by the seller in a few ways. Any affirmation of fact or promise about the goods that becomes part of the basis of the bargain, any description of the goods, like in a catalog, or any sample or model shown. The buyer doesn't necessarily have to prove they specifically relied on it, just that it was part of the deal.
Does the seller have to use words like warrant or guarantee?
No, formal words aren't needed, but mere puffery or statements of the seller's opinion or commendation generally don't create an express warranty. This car is fantastic, isn't a warranty. This car gets 30 mpg, likely is.
What about warranties that aren't explicitly stated, implied warranties?
Yes, the UCC creates important implied warranties. The big one is the implied warranty of merchantability under UCC 2314.
Who gives this warranty and what does it promise?
This warranty is automatically implied if the seller is a merchant with respect to goods of that kind. It warrants that the goods are fit for their ordinary purposes, adequately contain packaged, labeled, and conform to any promises on the label. Basically, they're decent, average quality for that type of product.
Can other implied warranties arise?
Yes, implied warranties can also arise from course of dealing between the parties or usage of trade within the industry, unless properly excluded or modified.
What's the implied warranty of fitness for a particular purpose? UCC 2315.
This one arises when the seller, merchant or not, knows the particular purpose for which the buyer wants the goods. AD knows the buyer is relying on the seller's skill or judgment to select suitable goods. If those conditions are met, there's an implied warranty that the goods will be fit for that specific purpose.
So if I tell the paint store owner I need paint for my boat dock and rely on their recommendation, there is an implied warranty it's suitable for docks.
Exactly. Even if it's perfectly good paint for houses, merchantable, if it peels off the dock immediately, the fitness warranty for that particular purpose might be breached.
Can these implied warranties be disclaimed?
Yes, under UCC 2316, but there are specific rules. To disclaim merchantability, the language must mention merchantability, and if in writing, be conspicuous. To disclaim fitness, the disclaimer must be in writing and conspicuous. For example, there are no warranties which extend beyond the description on the face hereof. Using phrases like as is or with all faults generally disclaims all implied warranties.
Okay, we have the terms, conditions, warranties. Now, how does performance work? Fulfilling the contract.
Under common law, the standard is usually substantial performance. A party fulfills their obligations if their performance isn't materially breached, meaning any deviations are minor and don't frustrate the main purpose of the contract.
What determines if performance is substantial? Is it subjective?
Sometimes. If the contract involves personal taste or aesthetics, like a portrait painting, a subjective standard might apply. Does the client honestly like it? But for most contracts involving utility or operative fitness, like construction, an objective, reasonable person standard is used. Does the work meet industry standards and function as intended?
What happens if performance isn't substantial, a material breach?
A material breach by one party excuses the other party's performance obligations. A non-material breach doesn't excuse performance, but the non-breaching party can sue for damages caused by the minor deviation.
What if the contract requires perfect performance?
If the contract makes strict compliance an express condition, then substantial performance isn't enough. But courts prefer to avoid forfeiture and usually interpret terms as promises rather than strict conditions unless the language is very clear.
What about divisible contracts, like paying per unit delivered?
If a contract is divisible, performance can be broken into corresponding pairs of part performances. A party who performs one or more parts can recover payment for those parts, even if they breach other parts of the contract.
How does performance work under the UCC for goods? Is it substantial performance too?
No, this is a huge difference. Article 2 of the UCC generally requires perfect tender. Under UCC 2601, the seller must deliver goods that conform perfectly to the contract terms in every respect: the right goods, the right quantity, the right delivery method, and time.
Perfect tender. That sounds strict. What if the goods aren't perfect?
The buyer generally has the right to reject the whole shipment, accept the whole shipment, despite the defect, and potentially sue for damages, or accept any commercial unit or units and reject the rest.
How does the buyer accept? Just by saying so.
Acceptance can happen by expressly stating acceptance, or by failing to make an effective rejection after having a reasonable opportunity to inspect the goods, or by doing any act inconsistent with the seller's ownership, like reselling the goods.
Can a buyer change their mind after accepting? Revoke acceptance?
Yes, under UCC 2608, but it's harder than rejecting initially. The buyer can revoke acceptance if the nonconformity substantially impairs the value of the goods to them and they accept it either reasonably assuming the defect would be cured or because the defect was difficult to discover before acceptance or due to seller's assurances. Revocation must happen within a reasonable time after discovering or when they should have discovered the defect.
Does the seller ever get a chance to fix a non-conforming delivery? A right to cure?
Yes. If the time for performance hasn't expired yet, the seller has an absolute right to cure by giving notice and making a conforming delivery within the contract time. UCC 2508. Even if the time has expired, the seller might get a reasonable further time to cure if they had reasonable grounds to believe the non-conforming tender would be acceptable, for example, based on prior dealings.
What if something happens after the contract is made that makes performance impossible or way harder?
This brings us to the doctrines of impossibility, impracticability, and frustration of purpose. The default rule, remember, is the performer's risk rule. You generally bear the risk of difficulties.
But sometimes performance is excused. What's impracticability under Restatement 261?
A party's duty to perform is discharged if, after the contract is made, their performance becomes impracticable without their fault due to the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made, unless the language or circumstances indicate otherwise.
So basic assumption, event happens, makes it impracticable, not my fault.
Pretty much. And impracticable usually means more than just more difficult or expensive. It often requires extreme and unreasonable difficulty, expense, injury, or loss. Think destruction of the specific subject matter needed for performance, a unique building burns down, or death incapacity of a person essential for a personal services contract. Supervening illegality also counts.
What's not usually impracticability?
Increases in cost, difficulty finding supplies, changes in market conditions, usually those are risks assumed by the performing party. Delegable duties generally aren't excused by the original party's death incapacity.
Does the UCC have a similar rule for goods?
Yes. UCC 2615 covers impracticability for sellers. Delay or non-delivery isn't a breach if performance as agreed has been made impracticable by the occurrence of a contingency, the non-occurrence of which was a basic assumption, unless the seller assumed a greater obligation.
What if the event only partially affects the seller's ability, like a shortage?
Then the seller must allocate production and deliveries among their customers, and potentially their own requirements, in a fair and reasonable manner, and must provide timely notice to the buyer of the delay or allocation. Unprofitability alone is generally not an excuse.
Okay, what's frustration of purpose? How is it different?
Frustration of purpose occurs when an unforeseen event happens that completely undermines or destroys one party's principal purpose for entering the contract, even if performance itself is still technically possible. The non-occurrence of the event must have been a basic assumption.
The classic example is renting a room to watch a coronation parade that gets canceled.
Exactly. Performance, renting the room, paying rent, is still possible, but the buyer's entire purpose for the contract is gone due to an unforeseen event neither party caused. Again, the frustration must be substantial, almost total. If the event was foreseeable or the risk was allocated in the contract, the doctrine doesn't apply. Usually the buyer claims frustration while the seller claims impracticability.
Okay, last major topic. What happens when someone just doesn't do what they promised? Breach of contract.
Breach is any failure to perform a contractual duty when it's due. One specific type is anticipatory breach or repudiation.
That's when someone says before performance is due that they're going to breach.
Yes, a clear, unequivocal statement or voluntary act indicating they will not or cannot perform when the time comes. Under common law, this gives the non-breaching party options.
What can they do?
They can treat the repudiation as an immediate breach and sue for damages right away, or they can wait until the performance date to see if the other party changes their mind, or they can treat the contract as rescinded. They generally must stop their own performance to mitigate damages.
How does the UCC handle repudiation for goods?
Similarly, under UCC 2610, when a party repudiates, the aggrieved party can await performance for a commercially reasonable time, or resort to any remedy for breach, like suing immediately, and in either case suspend their own performance.
What if you just have doubts about whether the other party will perform? Not a clear repudiation, just insecurity.
That's UCC 2-609, the right to adequate assurances. If you have reasonable grounds for insecurity about the other party's performance, you can demand in writing adequate assurance that they will perform. Until you receive such assurance, you can suspend your own performance if commercially reasonable.
What counts as adequate assurance?
It depends on the circumstances, the party's relationship, prior dealings, reputation, the specific grounds for insecurity. Failure to provide adequate assurance within a reasonable time, not exceeding 30 days, after a justified demand is treated as a repudiation.
Can someone take back a repudiation, retract it?
Yes, the repudiating party can retract the repudiation unless the other party has already materially changed their position in reliance on the repudiation, like hiring someone else, or has indicated they consider the repudiation final. Retraction must be clearly communicated.
What about installment contracts, where goods are delivered in separate lots?
UCC 2612 has special rules. A buyer can only reject a non-conforming installment if it substantially impairs the value of that installment and cannot be cured. But if the nonconformity in one or more installments substantially impairs the value of the whole contract, then there is a breach of the whole contract, allowing the buyer to cancel. But demanding assurances is often the first step.
Okay. Wow. That was a comprehensive tour through contract law.
We covered a lot of ground from the very beginning with consideration and offers.
Through acceptance, the complexities of the battle of forms, all those defenses like incapacity and mistake.
The statute of frauds writing requirement, the parole evidence rule limiting outside evidence.
Conditions, modifications, warranties, performance standards under common law, and the UCC.
Excuses like impossibility and frustration, and finally, breach and repudiation.
It really gives you a framework for understanding how promises become legally enforceable and what can prevent that.
Absolutely. The core idea is creating predictability and reliability in agreements, but balancing that with fairness and protecting parties from certain kinds of overreaching or unforeseen events.
Hopefully listening to this gives you, our listener, a much clearer picture of the principles underpinning agreements you encounter every day, from simple purchases to major contracts.
And thinking about all these rules, the need for consideration, the defenses based on fairness or capacity, the excuses for unforeseen events, it really raises a question for you to ponder.
Go on.
Considering this balance between the freedom to make agreements and the legal system's need to ensure fairness and deal with unexpected turns, how do you think rapidly evolving technology or major societal shifts might challenge our traditional understanding of what constitutes an agreement, and when should obligations be excused in the future?
That's a fascinating question. Definitely something to think about. If you have more questions on contract law or ideas for other deep dives, please do send them our way. Thanks so much for joining us today.
Thanks for listening.